So the question is generally, how successful are IEPs?
Well, you obviously know that you're raising a very big question about the IDEA and whether IEPs have been effective for kids, especially in urban schools. And I would agree that there are a lot of problems with them, although with advocacy, I think an IEP can become a very important tool for getting a kid, even in a crummy school, a better education that's tailored to their needs. That being said, my focus is really on the juvenile system, where the best juvenile facilities have excellent schools, and they use the IEP as a way of getting state and federal dollars to have very small classrooms, and that's the reason the kids get enough individual attention that they make these huge improvements in a few short years of being in a juvenile facility. So that entitlement, which a kid with disabilities has until age 22, isn't something we should take away from them because they have been involved in a serious offense. And we do take it away from them when they're direct filed.
So the question is, how do you start the process of working with a juvenile offender who's been sentenced as an adult?
That's an unusual post-dispositional case. So that is a special challenge for me. I'm not doing a lot of them because it requires me to look back at who he was at the time of the offense and try to recreate this developmental picture, and then to look at, well, what evaluation was done at the time, how much of this was presented to the court, and so forth. But in the typical case that I would work in, the kid would have recently been charged with the offense. And so I would have hours to work with them and all of their current records and their past Child Protective Service records, past mental health records, their current school records, and I'd be able to look at their IEP and see what evaluations have been done of their disabilities. And so by doing that, I can piece together a picture of where they are developmentally, and then from interviewing them and others who were involved in the offense and others who know them, try to figure out how disabilities, trauma, and immaturity affected the way they were thinking at the time of the offense, as well as thinking about, well, what would it take to help this young person not be reactive to trauma and get aggressive when somebody triggers them? Or what would it take for them not to be so slow in processing information that they're following along, not fully getting what a group of kids that they're involved with is doing? So it is fascinating. It's not that difficult to get this developmental perspective, and I am all in favor of juvenile defenders having this developmental framework as the way they approach the young person too. I'm not suggesting that you have to be a psychologist to think developmentally. I think it's really important to approach every juvenile offense developmentally, whoever you are. We expect people under 18 to be immature. That 17-year-old wouldn't be able to do a lot of the things that we allow 18-year-olds to do in this country. So I wouldn't disagree with you that some of you might even have had some immaturity when you were in college, and you had a lot of advantages that would have made you not have some of the characteristics that juveniles have who get in trouble. But that's not the point. It is not whether somebody over 18 has immaturity or has disabilities or trauma that affect them, but rather that because we expect that of someone under 18, and we used to have a whole system for responding to that, that it's important to think about that in the 17-year-old example you're giving. And then secondly, I would say that this each young person should be looked at individually. I think that in the case of a 17-year-old, he or she could be functioning much more like a 14 or a 15-year-old. On the other hand, there may be, when you look at their history and you understand what motivated them at the time of the offense, there might be reasons that the court would say, well, really, this young person can't be rehabilitated in the juvenile system. And giving that the opportunity for a judge to think that through based on an individual kid presentation is what I would argue for. And direct file laws at this point don't allow that in most of the cases of kids who are arrested now.
Ms. White, you talked about innovative services for victims, and I understand what you mean, but I'm not sure what is exactly what you do, and how do you get funding for that?
Well, we don't provide services at all. We're an advocacy organization, but what we're advocating for is that there need to be a level of victim services that are currently not available to people who most need them, particularly folks who could ultimately end up in the criminal justice system. So really what we do is go down to the legislature and say, why don't you rethink how you're allocating our public safety dollars in ways that make sense and helps build safer and healthier and strong communities, rather than just investing on the back end where you're going to get a really bad, as one business leader who's now working on this issue says, return on your investment. You don't get a great return on your investment when you are investing the majority of your resources on people at the back end of the system, and we could start to do more on the front end as well.
But your question on individual cases is so important that I'm working with a 16-year-old right now who was involved in a drug deal that went bad. He was going to snatch the weed and hop out of the car, and he had done that before. And he thought that was a very low-risk way of getting free weed, and he didn't have the money to pay for it. And his experience was that dealers don't usually do anything quickly enough to keep him from snatching and running. And it didn't seem like a crime to him, and he knew that he was protected by the fact that the dealer was doing something illegal, and they would be unlikely to call the cops on him for what he had done to them. And unfortunately, the kid, same age as he, who was the dealer, reacted, and they got into a tug of war that ended up tragically with the, I would say definitely the accidental death of the dealer, who was a classmate of the kid who was snatching the weed. And that kid is looking at 50 years for this tragic death. But that kid's mother, the victim's mother and father, no longer have their 16-year-old at the dinner table. And how do we respond to that? And the notion that, well, this kid should pay with his life for having taken their beloved son from them, that doesn't make sense to me for this kid. But how do we respond to that, mom and dad? And what is an acceptable societal response? I can fully understand why if my developmental assessment contributed to a judge saying, well, you made a lot of bad decisions and you have to do some time and you have to be serious about services, but we will release you at age 22 with a juvenile record which can be expunged if you do well in this program. And 22, that's 6 years if the kid is 16 now. That seems like a lot of time for a 16-year-old. But I can fully understand that the mom and dad don't think 6 years is very much to pay if that's how you view the criminal justice system, to pay for the loss of their child. And so I know you're talking about a lot of other kinds of victim services in advance of what contributes to offenses like this, but the whole question of how we do, as you point out, we do get separated. So if you're a victim's advocate and I'm working with a young person, I am not usually in court paying attention to what happens to the victims, and the juvenile is definitely not helped to face the parents of their victim, and is often not involved in a process that really helps them make any kind of amends to the community that was harmed or to the family, if we believe that any amends can be made.
Yeah, and to be clear, I mean, I think when we talk about resources, I'm talking about getting services in the community, but we're constantly evaluating policies, you know, that are, as the situation is happening, you know, and are victims getting support they need through the murder of their child? Are they getting good information so they even know what's happening in the system? These are the kinds of things we know victims want. And you know, the interesting thing is that we also know that's what those kids and their families want too. I mean, there's a whole bunch of like crossover in terms of what our systems can be doing to kind of help people navigate that process and not be so adversarial to each other that the kid isn't even allowed to say, I'm sorry. I mean, I've done a lot of defense work, and we would tell our clients, you can't talk to the victims at all. And then when I start talking to victims are like, you know, the one thing that never happened, no one ever said they were sorry. And you think, God, that would make a big difference. If someone killed your son, you might want to hear sorry at some point, right? And so we kind of created these barriers where that doesn't happen. But so to be clear, I'm not just kind of giving the prevention sort of message. I'm also saying throughout the system, where are we finding ways to really address the people who are the individuals who are going through the system? Because I can tell you, no one on either side feels well served by it the majority of the time.